My name is Christ Ambassador Amma McLean Williams. By Father's grace, I am the General Manager of the Everlasting Gospel Center, and it's a beautiful thing to have the Star-Cross team here so we can talk more and enlighten our audience concerning the everlasting gospel.
Watch out for BCS Showcase coming to you soon on Star-Cross Television.
Subscribe to BCS Star-Cross International and turn on your notification. Be engrossed too.
Would you be interested in a practical way to integrate your belief into your daily routine? You would? Well, we got you. My name is Celeste. I'd like to think I'm a very practical person but still struggle to weave my belief into my daily routine, but not anymore. Star-Cross Television is BCS flagship station broadcasting from our world headquarters in Calabar, Cross River State of Nigeria. Our YouTube channel offers a variety of content that inspire, enlighten, and empower, and we post every day. So, be practical about what you believe, subscribe, and turn on your notifications to stay connected on the go. Do it now. Would you be interested in a practical way to integrate your belief into your daily routine? You would? Well, we got you. My name is Celeste. I'd like to think I'm a very practical person but still struggle to weave my belief into my daily routine, but not anymore. Star-Cross Television is BCS flagship station broadcasting from our world headquarters in Calabar, Cross River State of Nigeria. Our YouTube channel offers a variety of content that inspire, enlighten, and empower, and we post every day. So, be practical about what you believe, subscribe, and turn on your notifications to stay connected on the go. Do it now. Would you be interested in a practical way to integrate your belief into your daily routine? You would? Well, we got you. My name is Celeste. I'd like to think I'm a very practical person but still struggle to weave my belief into my daily routine, but not anymore. Star-Cross Television is BCS flagship station broadcasting from our world headquarters in Calabar, Cross River State of Nigeria. Our YouTube channel offers a variety of content that inspire, enlighten, and empower, and we post every day. So, be practical about what you believe, subscribe, and turn on your notifications to stay connected on the go. Do it now.
History has it that Christianity has existed over 2,000 years, and the existence of God has been even before the world was. Over these number of years, several teachings have been put out concerning God and religion, until there came a time, a certain period, where the supernatural teacher, leader Olumba Obu, and the King of Kings, His Holiness Olumba Obu, brought a unique teaching to correct that which is wrong, unify the world's belief, and put us on the path to God's salvation. Join me, your host, Queen Sam, as we share with you these unique teachings every Wednesday, 7 p.m. West African time, only on the BCS Foreigner.
Watch Power Fruits and Vegetables with me, Emidio Umoyo, on Star-Cross Television.
My name is Christ Ambassador Amma McLean Williams. By Father's grace, I am the General Manager of the Everlasting Gospel Center, and it's a beautiful thing to have the Star-Crossed team here so we can talk more and enlighten our audience concerning the everlasting gospel.
Watch out for BCS Showcase coming to you soon on Star-Crossed Television.
Would you be interested in a practical way to integrate your belief into your daily routine? You would? Well, we got you. My name is Celeste. I'd like to think I'm a very practical person but still struggle to weave my belief into my daily routine, but not anymore. Star-Crossed Television is BCS flagship station broadcasting from our world headquarters in Calabar, Cross River State of Nigeria. Our YouTube channel offers a variety of content that inspire, enlighten, and empower, and we post every day. So, be practical about what you believe, subscribe, and turn on your notifications to stay connected on the go. Do it now. Would you be interested in a practical way to integrate your belief into your daily routine? You would? Well, we got you. My name is Celeste. I'd like to think I'm a very practical person but still struggle to weave my belief into my daily routine, but not anymore. Star-Crossed Television is BCS flagship station broadcasting from our world headquarters in Calabar, Cross River State of Nigeria. Our YouTube channel offers a variety of content that inspire, enlighten, and empower, and we post every day. So, be practical about what you believe, subscribe, and turn on your notifications to stay connected on the go. Do it now. Would you be interested in a practical way to integrate your belief into your daily routine? You would? Well, we got you. My name is Celeste. I'd like to think I'm a very practical person but still struggle to weave my belief into my daily routine, but not anymore. Star-Crossed Television is BCS flagship station broadcasting from our world headquarters in Calabar, Cross River State of Nigeria. Our YouTube channel offers a variety of content that inspire, enlighten, and empower, and we post every day. So, be practical about what you believe, subscribe, and turn on your notifications to stay connected on the go. Do it now. Would you...
evening to you out there, my beloved viewer. Thank you so much for staying tuned to the BCS Starcross Television on your most educative program, the Regnum Legal Viewpoint. Now, this is a program that brings to you legal issues, topical issues bothering us as individuals and the society at large. So do not go to anywhere, because we'll take a short break, and when we come back, you get to meet our guests in the studio and get to hear the topic of discuss today, which is very, very, very important. A topic you all would get to learn one or two things here. I am Irene Ulaita. Stay with us. We'll be right back.
Would you be interested in a practical way to integrate your belief into your daily routine? You would? Well, we got you. My name is Celeste. I'd like to think I'm a very practical person, but still struggle to weave my belief into my daily routine, but not anymore. Starcross Television is BCS flagship station, broadcasting from our world headquarters in Calabar, Cross River State of Nigeria. Our YouTube channel offers a variety of content that inspire, enlighten, and empower, and we post every day. So, be practical about what you believe, subscribe, and turn on your notifications to stay connected on the go. Do it now.
Welcome back, beloved viewer. Thank you so much for staying tuned. This is the program Regnum Legal Viewpoint, and in the studio today we have very own brother, a Christ ambassador, Justice Ahiapo. Peace of the Father.
Peace of the Father.
And also on Zoom, we'll be having Father's children as well on Zoom talk to us on this topic. I'll tell you the topic. We will be having Kenneth Itoro-Basi, Barrister Kenneth Itoro-Basi, and as well we will be having David Solomon as well, the father's son there. He'll be joining us shortly. So, but before we go to Zoom, let us first discuss with our guest here in the studio. Once again, welcome and thank you so much for coming to talk to us. The topic is court-martial and the law. Yeah. Let's get to know, in a layman's language or in a layman's knowledge, how would you define the term court-martial?
Now, court-martial is a legal proceedings that is being regulated by military laws.
Okay.
As a special court, the military personnel, rank and file, are subjected to court-martial.
Okay.
To make a comparison, we can liken the court-martial as the magistrate court. The court-martial is a special court for military personnel, and the laws that regulate the personnel emanates from the military laws. That is what court-martial is all about. Okay. As a civilian, you cannot be subjected to court-martial. Okay. Yeah. In Nigeria, we have the Armed Forces Act that also have a clear-cut definitions defining offenses that a military personnel can be subjected to trial. Okay. So when you see a military personnel being arraigned before the court-martial, then that military personnel had been charged for an offense. That is what court-martial is all about.
Okay, let's move on. Let's get to know the procedures adopted during the trial.
As a specialist court, it emanates from a petition. Okay. If one is reported for committing a particular crime or an offense, because they call it offense.
That is a military personnel.
Yes, within their operations, the petition will be raised by the panel that make up the court-martial. From there, the personality or the legal, the military personnel that is brought before the court-martial will be subjected to know what he is being charged for, and also given the opportunity to defend the charge. Most times after the petition, he has the right or she has the right to also reply in writing. That is how the procedure is commenced. Now from there, the panel who serves as the jury will have to assess the veracity of the personnel that is brought before them, whether he's telling the truth or he's lying, whether he's culpable or he can be discharged and acquitted of such charge. So it's purely a criminal procedure, a quasi-criminal procedure that is adopted in that proceeding.
Okay, so do we have different types of, are there types of court martial or is just one type?
Yes, in Nigeria we have two basic types.
Okay.
But in foreign jurisdictions or foreign countries where court martial is applied, they also have like three. In Nigeria we have the general court martial and also the special court martial. For some other countries, they also have the ordinary court martial.
Okay.
Ordinary court martial, the general court martial, and the special court martial.
Let's get to see, know the differences of the duties, how it works in these different types of court martial.
Yes, from, as I've earlier referred to you, the Armed Forces Act. I will take it from section 129 of the Court Martial Armed Forces Act.
Okay.
There shall be, for the purpose of carrying out the provisions of this act, two types of courts martial. That is, a general court martial and a special court martial. So, for one to be subjected to general court martial, the law also provides that you are subject to general court martial when you have a very serious offense. When you are charged with a very serious offense, then you are brought before the general court martial. Now all that it takes will be fully implemented. The panel will be constituted in such a way that you have a full panel.
Okay.
But for the special court martial, it might be a minor offense, and one officer can preside over such a trial.
Okay, what about the ordinary court martial?
The ordinary court martial is almost a semblance of the special court martial, but the ordinary court martial has to do with the rank and file. Okay. Those that are not officers as such. Okay. Now let me also add in the procedure that is adopted. The one that is placed before the jury or the panel, the court martial, has the right to engage a military lawyer or a civilian lawyer in course of proceedings.
Oh, really? Yes. You can engage a civilian lawyer in a military issue?
Yes, of course.
Interesting. Yes. Okay, interesting. So, since the court martial is a special court, right? Can the appellate court decisions reverse that of the court martial?
That is where the rule of law comes in. Was a trial is commenced and concluded at the court martial. Okay. The appellate court is the court of appeal, not the high court. If the person that was charged, the officer that was charged, is dissatisfied of the outcome or decision of the court martial, he is entitled, as of rights and constitutional right for that matter, to proceed on appeal at the appeal court, challenging the outcome of that trial. Okay. So at that stage, the officer can as well get justice, because the essence of going on appeal at the appellate court is to either prove that the person that was tried suffered injustice, or that the panel or the court martial had a miscarriage of justice or had erred in law in applying their judgment. Yes.
had a miscarriage of justice. That is
Yes.
interesting. Okay, what are the offense you understand that can make one, be summoned and be prosecuted?
That is what has given me so much of concern. There is a mixture from the Armed Forces Act, the law that regulates the proceedings of the court martial, had so much, both criminal conducts and civil conducts put together that will amount to an offense. Once you steal as a military officer, it amounts to an offense that will be tried at the court of appeal, at the court martial. The court martial, they will court martial you and try you for stealing. Even when you conducted yourself in a manner that you had occasional assault on somebody, as a military officer, you can be court martial, tried and be punished for it.
Okay.
So there is a whole lot put together that can even bring a military personnel before the court martial. So many, more than 30 something in number. Yes.
Interesting.
So many. You just go on and on, name them. They even have the civil wrongs that the military officer, when you even aid and abet,
Okay.
when you put somebody under custody unlawfully, all amounts to offenses that would lead you to. Even the most worst scenario, when you are involved in mutiny, you are involved in war crimes, all of them put together. So from a more grievous offense to even a lesser offense that the military personnel can even have a civil action against, all put together constitutes offenses in court martial proceedings.
So do we have, in part of their offenses, do we have the one that says if a military personnel, embarrasses a civilian or punishes unlawfully, will that person face the law?
Yes, it amounts to an offense that is punishable and prescribed by the Armed Forces Act.
Okay, interesting.
Once you harass, you intimidate as a military personnel, a civilian, you are subject to such trial. Funny enough, once a superior officer has any sexual or take advantage, sexual intercourse or rape a fellow officer's wife, you are subject to such a court martial proceedings. There's so many that time will not permit me to elaborate on.
So, from what you said earlier, the judgments delivered by court martial can be challenged in other regular courts of law.
Yes. Constitutionally, Section 36 of the 1999 Constitution as amended simply provides for fair hearing. So if you are dissatisfied with the outcome of the court martial proceedings trial, you are entitled to go to court of appeal. If you're also not satisfied with the decision of the court of appeal, if court of appeal find it worthy to uphold the decision of the court martial, you also have the right as an appellant to approach the Supreme Court for justice.
So, if the Supreme Court gives you justice, would the court martial not, challenge that judgment?
By procedure, the Court of Appeal and Supreme Court are superior courts. The Supreme Court is at the apex. Whatever the Supreme Court says is final. It's not challengeable. In fact, they cannot even reverse their own decision. It takes a lot for them to reverse their own decision.
Okay, that is good. And we can see the father's son, Barrister Kenneth Itherobasi. So, hello. Can you hear us, Brother Kenneth? Can you hear us? Can you hear me? Okay, okay. All right. So let's have your take on today's topic, court martial and the law. Everything you have, let's hear from you.
Whether I can say this, I didn't really hear all what Barrister Ahiako said. But the court martial is a special court that is set up to try people under the uniform military code. And in Nigeria, that court is set up under the Armed Forces Act, 2004. And there is the summary court martial, there is the special court martial, and there is the general court martial. And the differences between these court martials has to do with the officer that has the right to set up the court martial. Are you with me?
Yes, I'm getting you.
Are you with me?
Continue, sir. Yes,
Good.
I'm getting you.
So it has to do with whether it is, if it is a summary court martial, the officer, it is a special court martial, the officer that has the right, and if it is a general court martial, the officer that has the right. And under the Armed Forces Act, the people that have the right are the President of the Federal Republic of Nigeria, has the right to set up a court martial, the Chief of Army Staff, or the Chief of Defense Staff, and then the general officer commanding a battalion, a troop, also has the right to set up a court martial. Now, the court martial is usually set up to try military offenses as well as civil offenses. The military offenses can be mutiny, absence without leave, and such other offenses, like abandonment of duty posts, what we call desertion. They call it desertion in the army. Then those are military offenses. And then there are other civil offenses that will include rape, sodomy, theft, arson, and the like of the offenses that are under the criminal code. So that's the little I know about court martials.
Okay. For us today on the topic. Is that all you have for us today on the top?
Well, I know that court martials being a special military court, not that it is shot out of the Constitution, no. When the court martial have finished their deliberations, they hand out sentences. Those sentences may lead the convicted party to be imprisoned, make them to be sent out of the army, as in dismissed from the army. It might even lead them to be to a sentence of death, just like the civil offenses, depending on the gravity of the offense. And I also know that when the court martials are finished, the special court martial, the general court martial, or the summary court martial are finished, they have a right to appeal to the Court of Appeal by virtue of Section 18 of the Court of Appeal Rules 2016. The judgment of the court martial can be appealed against to the Court of Appeal, which is under the 1999 Constitution of Nigeria. So the offenses are spelled out in the sections of the Armed Forces Act. And it's in a wide variety of issues, including assault, battery, arson, desertion, mutiny, absence without leave, all those are offenses, sodomy, rape, they are all offenses under the Armed Forces Act, for which a court martial, theft, robbery, all of them are there. It's just that they are being segmented into military offenses and civil offenses. I'm listening for your question, if any.
Okay. Why is it that the laws provided by the Armed Forces Act not part of law school curriculum? Did you get that?
Get that?
Yes. Why is it not part
Why
of?
is it not part?
Why is it that the laws provided by the Armed Forces Act not part of law school curriculum?
It is part of the law school curriculum.
Okay.
Under Civil Procedure and Criminal Procedure Act, Criminal Procedure. That is what is taught at the law school. So it is part of the curriculum. It is just a topic under it. But you know, most people do not go to law school with the intention of coming out to become army lawyers. And so maybe most times this particular attention is not being paid to it. So I know that when you join the army, that particular law will now be taught to you during military training at the Nigerian Defense Academy.
Okay.
You got that?
So, okay, continue, sir.
So because most people, yes, because most people don't really, intend to come out and become military lawyers, since the army, the military, when we say the military, we mean the army, the air force, and the navy, and even the paramilitary, what they normally call military police. So most people do not intend to come out and become army lawyers, and that is why particular or specific attention is not being paid. But under this criminal procedure and civil procedure, it is being taught.
Okay. Okay.
Yes.
So my next question. How is it enforceable by the military when the regular court convicts a military personnel of an offense?
Let me get you, please.
So I asked, how is it enforceable by the military when the regular court convicts a military personnel of an offense?
Okay, it's possible. It's possible for the regular courts to convict a military personnel of an offense. This is how it happens. If a military personnel commits an offense and is being taken to an orderly room trial, you got that?
Yeah.
If the person is being taken to an orderly room trial and dismissed, the regular court can try him for the same offense and have him convicted. It's possible that way. But first and foremost, he has to go to orderly room trial, and the army have to dismiss that person. And then if the offense was an offense that can be taken care of by the ordinary court, like fraud, like armed robbery, like capital offense, murder, then the regular court can take over after he has been dismissed and is charged and convicted accordingly, if he is guilty.
Okay.
If that does not happen, then it is if he's still a certain military person and did not go through that procedure I just mentioned, then it is the Armed Forces Act, that is the court martial, that will hear the matter and convict him.
Okay. Interesting. Okay.
Yes.
We'll get back to you, sir. Let's talk to Christ Ambassador Ayako here. So, what do you have to say about this particular question? How is it enforceable by the military when the regular court, convicts a military personnel of an offense?
To start with, if assuming the military personnel that falls within the category of an armed forces, either be it a naval officer, an army officer, or an air force officer, You might even fall within the rank rating, the rank and file. It's not necessarily a high-ranking officer.
Okay.
If you are caught or you are allegedly being said to have committed an offense, what the military does is to investigate, try the person, and if the outcome of that investigation, they will now hand over that military personnel to the police for for formal prosecution in the regular court.
Okay.
Immediately that is done, the military finishes its own investigation. They hand the person, the officer, to the police, who will in turn now conclude investigation and prosecute that military officer in a regular court. The outcome of that court proceedings or trial will be as good as the court martial decision. If the court convicts the military officer, he goes to jail and he will serve the prescribed jail terms as provided by the law. The military cannot shield such an officer. He must be faced with the law. But the first and most important thing is that, as Kenneth has said, he must be tried in the orderly room. Then, after conclusion, they hand him or her to the police. So he's not absolved from the regular court trial.
Okay.
In other words, if it is what the court martial can also try, once the officer is found guilty of an offense and jail terms is pronounced according to the Armed Forces Act, he goes to jail. From the military setting, he will be handed over to the prisons authority. Now we have it as a correctional center. Yes.
Okay.
Once they invite a witness in the court martial proceeding to attend to testify, even if you are a civilian, if you fail to do that, the court martial will cite you for contempt, and you can also be jailed for that offense.
Are you serious?
Yes.
Wow.
Yes. They have that power to invite any witness, subpoena any witness to appear before the court martial to testify.
Okay, so in a situation whereby, like, I want to liken this particular situation to that of a civilian that maybe commits an offense and flee away, and then the police will now come to arrest either the mother or the father or the brother, so that the culprit will come out. Is this also applicable in military?
Not at all.
Okay.
Even the scenario you've just painted, the law had prescribed such an action.
But it's still
and
ongoing.
it's very, very wrong. The Anti-Torture Act, that is the instant law, the Police Reform Act, that is 2020 Police Reform Act, also clearly says that you cannot arrest a relative of one who is a suspect of a crime being allegedly committed.
Okay.
So the military cannot also do such a thing.
Okay.
Once you have been caught for a crime, or you're said to have committed a crime as a military personnel, you elope, the law will wait for you. And once you're back, you will be charged for it. Your mother, your father, your sister, your wife cannot be charged for the offense you have committed, allegedly committed.
Okay, so we have here on Zoom present, we have here the father's son, as Grace Archbishop David Solomon is here with us. Peace of the Father, sir. Okay, today's topic, court martial and the law. Let's get to hear your take on this topic. Everything you want the viewer out there to know about court martial and the law. Over to you, sir.
Court martial is a special court with legal proceedings meant for only people who are under the military law. It's not meant for civilians. For every society, discipline is the watchword. The military is not left out. And where there is no law, there is no offense, there is no sin. So to ensure that military men comply, certain laws are kept. There are some simple and easy offenses that can be dealt with, but very serious criminal offenses are the ones that are dealt with using the court martial. The court martial can be convened by the Chief of Army Staff, Chief of Defense Staff, the Commander-in-Chief of the Armed Forces, brigade commanders, general officer commanding, and then for any rank less than major, you cannot convene a court martial. The composition of the court martial, if someone is accused of an offense, offenses that can be tried by court martial are relating to things like aiding and abetting the enemy, arson, cowardice, desertion, and a few others. Now, when the court martial is convened, the composition is such that the accused must not be senior to the members of the court martial. The head of the court martial, the president, must be either the mates of the accused or the senior. Likewise, the members of the court martial. The people are allowed to be junior in court martials are the liaison officer who is around to run for administrative things, and the judge advocate who must be a lawyer of about 3 years experience. So if a brigadier general is being tried, the head of the court martial must be a brigadier general or a senior person. And the judge advocate can be a captain or major. Administration of oath, just as is done in the regular courts, the judge advocate administers oath to both the witnesses and the accused based on their faith. Jurisdiction, well, if 3 people commit an offense from 3 different units, the unit with which the accused, the unit of the most senior officer, if, for instance, 3 senior, 3 offenses, 3 military men commit offense, one is a captain, one is a major, one is maybe another major too, then they'll look for the most senior officer of which any of these people belong, and they will do the jurisdiction there. There are about 3 types of court martials. Now only 2 are left. We used to have the special, the court martial, the general court martial, and one which we used to be done in the field operational areas called field or summary court martial. Field or summary court martial can sentence someone even to death on the field there during operations. But that has since been done with. And we now have the general and the special court martials. The rules of proceedings of court martial are contained in the Manual of Military Law, or the Rules of Proceedings, Army, 1972. And we have that of Navy, we have also that of the Air Force. I don't know whether there's any other thing you want to talk about, but also challenging the composition. If an accused is uncomfortable with any member of the court martial, he has the right to object. And if that happens, the president of the court martial will adjourn and replace that unwanted member by a waiting member. There's always a waiting member. If, perchance, the accused still is unhappy with the replaced person, Then the president of the court martial would adjourn completely and get back to the convening authority, whereby they will now give another person to take part. This is part of the rule of law, to ensure that nobody is intimidated. Then for decisions made by the court martial, rulings of the court martial, it can be challenged in the law courts. If you are court-martialed and you are uncomfortable with the outcome, you can approach an appellate court and the ruling can be overturned if the rules of law were not followed. I don't know whether there's any other thing you want me to add.
Yeah, there's a question I want to ask you, which I asked Barrister Ayakwo as well as Barrister Kenneth. How is it enforceable by the military when the regular court convicts a military personnel of an offense? Because I am suspecting that maybe the military personnel would want to, cover up the colleague, or want to play smart because he's the colleague, and then a regular court out there has convicted him for an offense, and then the military personnel would not want to carry out. So how effective is it?
Thank you very much. By the law of compact, every military man is bound by two laws: the civil law and the military law. And when you go out for military operations, you are to obey the international humanitarian law also. The military man is aware that if he commits an offense, he can even be dealt with more than the civilian. So they're always more careful. If a civil court convicts a military man, the offense has to be reported to the commander. Then the commander will let go and put this military man on administrative list. Then he will go and face. They can assist him using the Department of Army Legal Services, Directorate of Army Legal Services. Give him a military lawyer to see whether they can defend him. However, if he is convicted, and for instance, he's to be jailed, even if it is for 1 day, the moment you are pronounced jailed, the military will dismiss you with ignominy because you have brought shame and indiscipline to the military. So the military does not cover up anybody who commits an offense. If, for instance, a military man connives with a civilian and they commit armed robbery, there is armed robbery in the Armed Forces Act and there's armed robbery in the Civil Act, because the Armed Forces Act is part of the laws of the Federation of Nigeria 2004. Now, you cannot, for instance, charge the military man in the military circle and also go and charge him in the civil. That would be a double jeopardy. So what can happen? If, for instance, the man had traveled to, let's say, Onitsha from Lagos without taking permission, that is an offense. That means absence without official leave. The military can charge him for traveling without permission, convict him, and if possible, if he's to be dismissed. Then they will now hand him over to the civil court to try him for armed robbery. You can see that the military man is even more scared to commit offense than the civilian.
Okay.
So a lot of times when you see a policeman letting go the military man along the road in the traffic, is because the policeman is aware that this military man knows the consequences of committing an offense. You'll be charged under the military law, charged under the civil law, or outside international humanitarian law can also grab you. So the military does not encourage indiscipline in whatever way. Good commanders will warn their colleagues to take care of their driver's licenses, their documents, everything that has to obey the laws of the society. The military encourages it. So if you run foul, they'll throw you away.
Okay. I have a question. So I want you to enlighten the civilians. As a military personnel, a brigadier general, people in your status quo will refer to ordinary civilians like us, like they'll call us bloody civilians. So in a situation whereby a military personnel assaults a bloody civilian, what steps should the civilian take, to get justice?
Military men do not just go out on the road to assault civilians. The military man is aware that the laws of the land should be obeyed. So they are law enforcers. And so if you see a military man assaulting, according to you, a civilian, something must be wrong. If, however, he is doing that illegally, then what the civilian needs to do is to report to the nearest military unit, not to start to encounter the soldier. If you can get the person's name and get his unit, you can march to the unit and complain to the commander. This and this happened, such and such a thing happened, and a good commander will take it up.
Okay. Question. So we know in Nigeria today, police, we are still trying to change the system where you will have to bribe a policeman for 50 naira, 100 naira, 200 naira, and I'm sorry to say that we see also the military personnel involving in taking some tips of some amount of money. Does the law, is the military arm in support of this, or is totally against it? And if a military personnel is found, wanting in this particular aspect, what is the punishment?
The military man does not take bribe on the road. They are so disciplined. However,
as a brigadier general, you would stand for the military, but we are on the streets. We see what is going on, but it's okay. Go ahead.
If, however, like there can always be a Judas among the 12 disciples. If, however, someone is indisciplined enough to do that, he will be doing that with fear, because no commander, no military officer will encourage such indiscipline. It's a shame, and it brings down the image of the Nigerian army. So if such a thing happens, like I said earlier, is not to harass the military man, is to get his number, get his name, and report. The best you can do is to report.
Okay. Thank you very much, Brigadier General David Solomon. Thank you very much. Still be there. We'll get back to you, as well as you, Barrister Kenneth. We'll get back to you. Let's come back to the studio. So,
thank you very much.
He has said a lot. Do you have anything to add to what he said?
Quite frankly speaking, he has made his mind out because of his experience. My worry is the level of the lawyers, the civilian lawyers' participation in court-martial proceedings. From a close look at how these proceedings are conducted, majority of the Nigerian lawyers are not part or do not have this awareness that they can as well appear before court-martial trials. It has been on a very low ebb.
Okay.
The civilian lawyers, like we that are not in the military, had not developed our practice to the extent of having briefs and appearing in a court-martial proceedings. The high-profile lawyers can do that, but it's part of our job to defend military personnel or officers that are brought before court-martial. We can as well do the regular court proceedings, cite the relevant laws, both evidence
Not
act,
being a military.
not being a military,
okay.
because what goes on as a trial is linked to criminal procedure.
Okay.
So as a lawyer with a vested knowledge in criminal law, evidence act, can as well do a very good case and defend those that were innocently charged and brought before the court martial. These are the things that we should also be reminding ourselves as lawyers. Once we have the opportunity of going before court martial trials, of course we are fully equipped and armed with the laws to do good cases for our clients. That is the aspect I want to emphasize on. It has been just that, or if you are not in the military as a military lawyer, or you were once a retired military officer that is now a lawyer, is just left for you. It's an area of the law, of legal practice, that we are yet to really explore. There are a lot of cases that led to so many officers being dismissed. So many have been suffering unjustly, and they've not been heard because good lawyers, or we don't take it as our duty to defend military officers before court martial.
Maybe because you think that they also have good lawyers in the military arm that can as well defend them.
Funny enough, the court martial, those that make up the panelists, majority of them don't have legal knowledge.
Are you serious?
Yes, that is how funny it is. They only rely on what the judge advocates will advise them. The lawyer amongst them, who probably, as Brigadier General David Solomon has said, will be at least a post call 3 years post call. And you can imagine a lawyer who is over 20 years at the bar defending a military officer, and the 3-year post call lawyer is advising the panel. I mean, it cannot go sway, because to convict for criminal offenses, there is just one standard to establish, one element. It must be beyond reasonable doubt. If they are not convinced that the man did not commit the offense, there is no way they could even convict him. You must be convinced, because it has been proven beyond reasonable doubt that the man appearing before them, charged for any criminal offense, is guilty of that offense. Now come to think of it, one without a legal knowledge, we don't have that system. I'm comparing the court martial proceedings with that of the other countries of the world that practices the jury kind of trial, where laymen, well respected, will sit down and listen to proceedings, and they will go back based on the advice of the legal officer, and they look at the demeanor, and they will be convinced that, oh, this man actually committed this offense. But in the legal system in Nigeria, the one presiding must have legal knowledge, must be a lawyer, a qualified lawyer for that matter. But in the court martial proceedings or trial, I mean, the panel, the 4, 5 of them, 3 of them, might not even have the least knowledge about the law. But because they are high rank.
Are you sure?
Yes.
Is Grace Solomon, David Solomon, are you there? Can you hear me? Okay, please kindly unmute yourself. Okay. Did you hear what Christ Ambassador Justice Ayako said?
Yes, I heard him.
What do you have to say to what he just said, that the military court marshals, the personnel there, do have little or fair knowledge about legal aspect of trying to defend or prosecute a military personnel that has committed an offense. How true is this?
Yes, a few of the court martials I've attended, it is not compulsory that the head or members of the court martial must be lawyers. Military law is different from civil law. And for someone to rise to the rank of a colonel, brigadier general, he must have been taught some rudiments of certain things which he needs to know. Besides, the judge advocate, who is compulsorily a lawyer, is always there to hold all the constitutions, all the law books, and guide the president of the court martial. The president of court martial talks to the judge advocate every second. What do you say? What does the law say? What do you say? What does the law say? And at the end, they do a closed sitting and decide on the findings and before the judgment is passed. And besides that, every person who is accused in a court martial has the right to come with a civil lawyer. So the defense will be talking, the accused people will be talking, and you'll be hearing their legal jargons while you are sitting there as the president of the court martial with your own judge advocate. So you are talking about minimum of three lawyers, one on the defense, one on the accused side, and one on the part of the composition of the panel. So there's no way they can run foul of the law. Besides, when the proceedings have been given and the judgment passed, it will be sent back to the convening authority. The convening authority will now send it to the Directorate of Army Legal Services for advice. Directorate of Army Legal Services, made up of grade 1 lawyers, will now advise the convening authority, what the court martial did is either right or wrong and all that, and then they will now go ahead. They can decide to cancel your judgment or not, because the court martial is aware that if you give wrong judgment, you can go to an appellate court and it will be quashed.
Okay, I like when you said they will go out for grade 1 lawyers. I like that. Okay, Barrister Kenneth, sir, do you have something to add to that? Please unmute yourself. Unmute yourself.
The problem I see with military court martial has to do with the number of years of experience of the judge advocate. 3 years as a lawyer, that lawyer is still unable to find his feet. So I think yes, 3 years as a lawyer, that person is mostly not unable to find his feet. Let's be clear on it. So the years of experience is too low. But as for everything that the general have said, he is right. He is very, very right. But I am thinking that since the army is the one providing for the special or general court martial, that the person that should be sitting there should be at least 10 years post-court experience, because that is he is in a position of a judge. It's just like saying that somebody that is 3 years old at the bar should be appointed a judge. That person does not have the experience at that level of practice. So that's my own take on that. But every other thing he has said is correct. And another thing I want to add is that Justice Ayako made mention of the fact that the person has to be the offense has to be proved beyond reasonable doubt. The rules of law, the rules of constitution, under section 36 of the 1999 constitution applies to the court martial. And so the person has a right to bring any legal practitioner of his choice from anywhere to defend him, depending on the gravity of the offense and whatever he feels might stand in the way of justice to him. So he has a right to be given notice of the offense he has committed. He has the right to defend himself. Documents have to be presented. Those are the provisions of section 36. And most importantly, you have to remember that that court or tribunal, that is what that section says, 36 subsection 1 of the 1999 constitution says that that court or tribunal should be set up in a way and manner to ensure impartiality and independence. Those are the two key words. independence and impartiality. So if there is no independence in that, it can be challenged. If there is evidence of impartiality, for instance, when the two army officers already had a problem and one of them is appointed as a member of the panel or president of the panel, there is likelihood of impartiality. Even the section of the country where he comes from, that the person has committed the offense. And for instance, when an army officer committed offense against the president, and then a court martial is brought in from that section, then there is impartiality, because the person will be partial, that it is his man that is to be removed from power. So all those constitutional checks have to be set up. Like we talk about jeopardy is right. When the person has already been tried by a military court, taking him to a civilian court will be double jeopardy. The only way out is for him to appeal to the Court of Appeal, like I have said. An appeal from a court martial goes to the Court of Appeal. And whatever was done at that court martial, if it can be raised properly, can be overturned at the Court of Appeal. So that's basically the way it goes. And don't forget that every offense that is in the criminal code is under the court martial, the Armed Forces Act. Every offense is there. So if the man commits offense that is military, the punishment will be militarily met out. If he committed an offense that is civil in nature, a civil punishment will be met out to him. That is how the court martial is being run.
Back to you, Brigadier General. Yeah, I can hear you. Thank you very much. Back to you, Brigadier General David Solomon. So, do you accept with the concerns of Barrister Kenneth Itorobasi that a presiding judge of the court martial should have at least 10 years experience?
Let me say here that the word is not presiding judge, it's just judge advocate. The head of the court martial, the president of the court martial, is a senior officer who has been tested and known to have gone administrative processes, and he knows what to do. Now, someone is accused, and then a court martial is set up. The book, the Armed Forces Act, says minimum of 3 years. If you have a 20-year-old lawyer, better. But the Armed Forces Act, unless reviewed, you can carry it to 10 or 15 years. But if you don't have a 10, 15-year-old lawyer, what do you do? So that's why the Armed Forces Act says minimum of 3 years experience as a lawyer. You can be called in as judge advocate to advise the president and members of the court martial. Besides, like I said, the accused and the accused and the defense, all of them will have their lawyers who will be there to make sure that nobody is wrongfully jailed or penalized. So I agree with you that the minimum could be raised to 5-7 years, but that has to be with the review of the Armed Forces Act.
Thank you very much. Thank you. Let's get back to the studio. So, how best can the fundamental rights of a military personnel be guaranteed?
First and foremost, most of the trials that is carried out at the court-martial proceedings are more or less a closed-door proceedings, and it violates to a large extent Section 36 of the 1999 Constitution, which states in part that trials must be conducted in the public. We are not privy to what goes on in court-martial trials. The public does not have that unfathomable access. So for one to really have a guaranteed right, you must be subjected to that open court public hearing trial. But conventionally and in practice, you hardly can see court-martial trials being covered by the media. You hardly can see it. So how do one now feel that his right is fully protected, his fundamental human right is fully protected? Once you are subjected to such trial, you are not even free to express yourself outside the trial. You are not even free to have the best of the legal lawyers, the best of the legal services from lawyers. You know, the legal aid, I'm very sure, cannot easily be availed to the accused person. So these are the things we need to see before a military officer appears before the court martial. The torture, they will first of all even put you under confinement and possibly torture you to the extent that you've already accepted the guilt of that offense.
Is it the one they call the guard room?
Yes, that's their
Okay.
their own language.
Okay.
You see the procedure, they will get you arrested, they will confine you to a state of where you can even lose your senses. So the torture alone before you are brought before the court martial, be it physical, mental, or just name them. How can you be a judge in your own case? The military, the armed forces, whether it's army, navy, or air force, they are accusing you of a wrong being committed. They are the one presiding over a case you are appearing before. It does not make sense. You cannot be a judge in your own case. We are saying that if a court martial is set up, let the accused person have those fundamental human rights availed him that can enable him efficiently and effectively defend himself. It doesn't work that way. I have never seen from a close observation where a personnel, an army officer having been arraigned before the court martial had not even gone half his conviction. So we are saying that that modus operandi, that procedure of trial should have a human face, should be seen as one who is presumed to be innocent
Okay.
before even conviction.
Okay, I see His Grace General Essien and General David Solomon laughing already. I think he has something to say. Let's hear from you, sir.
Thank you very much, Zacharias.
My brother Justice, it is not true that before the accused is taken to court martial, is already tortured. In fact, that is not even allowed in the military. Now, the guard room you're talking about is a place of confinement to restrict you from harming yourself, from tampering with the evidences and all that. So they keep you there until the court martial is set up. Now, if you set up a court martial, you have to ensure, since you are under the laws of the Federation of Nigeria, you have to ensure as a commander, as a convener of that court martial, that the right things are done. And what is it? You get people who are not biased to preside over the case. And like I said earlier, the accused has a right to object to membership of that place. Secondly, there are two types of sitting in the court martial: the open sitting and the closed sitting. The court martial is open to witnesses, open to people who could come, if they know about it, to observe about the case. Civilian lawyers are brought in. People
Is it also open
allowed.
to media personnel?
No,
Is it also open to media personnel?
No, the Army Public Relations Department is there to cover for the media. Meanwhile, it is just a proceeding to see that you are not guilty before you are jailed. So the accused person is made to stand in an open court. Witnesses are called, including civilian witnesses. Now, if, for instance, a civilian is called as witness for a court martial and he refuses to go, he can be tried in a civil court for failing to appear. How do you call that? You have failed to appear, just like you can do in the law courts. There's a name people call it. Now, the closed sitting is when the findings are to be discussed. Only members of the board and the judge advocate will sit and they will now look at it and say, okay, these lawyers have argued this way, the other ones have argued this way. Judge, advocate, what do we say? What are the evidence? The Evidence Act is what guides every lawyer. The Armed Forces Act is there. The Manual of Military Law is there. The Board of Inquiry book is there. So we have so many books to guide the military people. So it is not true that their fundamental human rights are tampered with. And the so-called fundamental human rights I am saying now is because you are wearing uniform, some things are denied you. Some liberties are denied you, even in the Constitution, because you are wearing uniform. You can be pushed left, right, center, posted to northeast, posted to southwest. You must movement is restricted. Of course, if I'm a civilian and you restrict my movement, I can take you to court. But the military man, for the job to be done, you can restrict his movement. So liberty of speech, you can't talk anyhow as a military man.
Yeah.
And so many others. If you check the Constitution, you see fundamental human rights. This can happen except the military man. This can happen except members of the armed forces. This and this except members of the armed forces. So we are even made ab initio and denied certain rights.
Okay, thank you very much, Brigadier General David Solomon. We are actually running out of time. Thank you very much. We want to go quickly into the YouTube platform. We had some questions. I believe these questions had already been answered during the course of discussion, but let's just read it out. We have Emmanuel Israel Obioiso said, perfect peace of the Holy Father, beloved. Gladys Oyebo says, nice to be here today. Special greetings to our unique learned speakers, commending all of us. Kaita Chibong says, perfect peace. Gladys Oyebo asks the question, says, please let us know the mode of operation when a military officer is brought before the court. How does the judge handle this case? I believe that was already discussed. Kaita Chibong says, good to be here once again. Well done, presenters. Welcome our guest speaker. And the last one here says, from Gladys Oyebo says, please, what happens when, for instance, a military officer is indicted wrongly? Where else can such a person seek for justice? I believe we said that earlier, that it can go for the Court of Appeal to seek justice. So this is how far we can go. Thank you very, very much, Barrister Kenneth Ithoro Abasi. Father bless you. Thank you so much for joining us. Thank you for all you had to share with us. Father bless you. And thank you so much, Brigadier General David Solomon. Father bless you. Thank you so much for your contribution. I believe our viewer out there have learned a lot. Thank you very much. I appreciate it. Okay, back here. Thank you. Back here in the studio, thank you so much, Christ Ambassador Justice Ayakwa. Today was a wonderful one. I believe out there, our viewer, those that are military personnel and those that are bloody civilians, like they used to say, you've learned a lot. You've learned a lot today. It's been a wonderful time out here with the topic court-martial and the law. As a military personnel, you know what you stand to face if you break a law. Okay, so you have to be upright because you are supposed to be examples to others. Thank you so much. It's been a great time here. I'm Irene Lighter. Do have a wonderful weekend ahead. Remember to always watch Starcross Television. This program comes your way every Friday, 7 p.m. to 8:30 p.m. Nigerian time. Do not miss out. See you next week, same time, same day. Bye-bye.